Now, let's come to the data protection bill. Remember, the bill that will govern rules around social media usage of data, how companies use data, our data that we generate, personal and non-personal, as well as liability of companies, has been tabled about 2 years ago. It's very wide-ranging. A joint committee has been mulling over this bill. They submitted their report in both houses of parliament today. So what have they said? What do they want to change is the question. So they want to widen the scope of the legislation by including non-personal data in it. They're talking about social media platforms having more responsibility. So they should be treated as publishers and be held accountable for the content they host. This is the tricky one and perhaps slightly controversial one. And there are other suggestions that they've given as well. Let me go across now to Nikhil Pava of Media Nama to break it down for us. Nikhil, great to have you back on the show. Let's begin by you explaining why this report is important. It's of course not binding on the government to present it, right? So will it really make a big difference, and does it move the process of adopting this bill along?
Well, Tamanna, while we have a fundamental right to privacy, we still don't have a data protection law to enforce that fundamental right. And that's why this report is important, because it moves the process forward. Like you said, the government may not necessarily accept all the recommendations, but it's likely that when this bill does get tabled, it will have bipartisan support, because it was a bipartisan committee that has given its consent to this report. Of course, there are dissent notes on some very substantial clauses, but on the whole, it's a step forward. I have some serious concerns about some aspects, but let's not forget that this is an important move. It could have been done better, not just by the government, but also by the JPC. But it's high time that we move forward and pass this bill.
Okay, so we've at least moved one step forward. It will have a seal of bipartisan support because, of course, it's a joint parliamentary committee. Okay, Nikhil, the key pointers of what are the new suggestions in this report?
Well, I think there are some major changes, especially around whether the government has any accountability built into this. And by the looks of it, they have very little accountability and a lot of power. So while there are some superficial changes to try and bring the government under some regulation on this bill, it gives the government far too much power over the Data Protection Authority, but also does not do enough to address government surveillance issues, especially, for example, what we've seen with Pegasus in the recent past. So the government can still, under certain minimalistic clauses of, proportionality, allow agencies to be exempt from the provisions of this bill. But it's a bit disappointing, because the JPC had this opportunity to bring the government to hold the government to account. It's also, if you have to go back to the genesis of this entire bill and this entire process, which was Justice Puttaswamy's case against the government in case of Aadhaar on the grounds of the fundamental right to privacy. So a bill which owes its genesis to a challenge to the government's rights to collect data by force now is now creating vast exemptions for the government. And not surprisingly, many MPs have dissented on this particular ground because of the largely free run that it gives the government. Then the other key aspect is
so that's what the original bill also had. Let me right. Let me come to it one by one. So let's come to the inclusion of non-personal data, or the suggestion that non-personal data is also included in the scope of this bill. What do you make of that?
So look, that's why the name has been changed from the Personal Data Protection Bill to the Data Protection Bill. And frankly, non-personal data and its regulation is completely separate from personal data. The definition of non-personal data is still not very clear. There is very little by in terms of laws and even research-based understanding on what non-personal data really is and what its benefits are. But it goes back to this, that it's the government and the committee seems to be more concerned about the economic utility of data, and by the looks of it, less concerned about protecting the rights of citizens, which is why you see this non-personal data being bunged in along with personal data. And I think that should have been completely separate processes. There's already a committee that has a consultation on it. That report is still not public. And really, there hasn't been too much debate on non-personal data, even in Parliament. I think these are competing issues: economic growth, privacy, and non-personal data holds a substantial risk to an individual's privacy. So even as the definition isn't still clear, I don't think this should have been mixed together. To be honest, non-personal data deserves
Yeah.
its own separate discussion.
So, so now let's break this down to understand more easily for our viewers. Essentially, so for example, non-personal data being governed under this same law, would that impact how companies use the data that we generate to, for example, advertise products to us?
Well, not so. It really depends on. So, non-personal data is a complicated construct. It really refers to anonymized data, which is not pertaining to a particular individual, which can be used by something that's been conceptualized as a data trust, and then given to the government to economically benefit from it. But the risk with non-personal data is, for example, if you have data on, say, which parts of India are consuming beef, or which parts of India does, let's say, food ordering go reduced during Lent, then you're able to target particular communities by identifying them on maps. So non-personal data can be combined with personal data for profiling of people, and I'm just saying that that needs to be a completely separate uh, uh, set of regulation. It needs a separate consultation for a bill, separate law, and the global view on non-personal data is still not finalized. And on privacy and personal data, it is. So I think there need to be two separate processes, but they've just mixed them together because I think the government just doesn't want to go through the process of passing another bill for non-personal data, and it just wants to leave this regulation to the Data Protection Authority so that rules can be made, perhaps without the oversight of Parliament.
Okay, let me talk about the other key suggestion here, which is the responsibility of social media intermediaries. Explain this. How does this now change, and how does it impact them if they're all going to be looked at as publishers?
So that's not there in the bill, Amana, and that's the interesting part. This is, and when I was reading the report, I was also surprised by this commentary by the JPC on treating social media entities as publishers, because what does content regulation and regulation of what is being published on a social media platform have to do with privacy? Um, but so the JPC has commented on it, and it's recommended the creation of a separate uh, regulatory authority like the Press Council to regulate content on social media. But this is not a part of the bill as such. The bill only concerns privacy. Of course, there are other concerns related to this entire exercise of creating a so-called Ministry of Truth for social media, which is that an entity that can take down content and punish social media intermediaries for the content that is published on them. the internet will not survive this kind of a construct. Social media platforms will not survive this kind of a construct, because the moment they are treated as publishers and they're held liable for content that you and I might be putting up, with billions of posts going up every day, something or the other is bound to be illegal. The platform will never survive that kind of liability. And so this is, I would expect that if any such construct comes up where social media entities are treated as publishers, they are going to go to court and take it to the highest level, because they can't survive it. Imagine all the video that is published on YouTube, or on Instagram, or even on Indian platforms like Josh and Chingari. They will never survive the liability of that content. So the JPC really should, this was not the remit of the JPC to go into content on platforms. They have commented on it, but it's not a part of the bill.
All right, so it's a very interesting story to follow, because the ramifications are wide and very large on all of us. Thank you so much, Nikhil, for joining us today and breaking all of that down. We'll take a very short break on the show, but we'll be back with more. Yes, sure, Nikhil.
Sorry, Tamanna, there's one strange part of it, where the age of children is meant to be 18 according to this bill. And if they're younger than 18, they have to get the consent of parents, which makes absolutely no sense, because a lot of young adults are coming of age, they're exploring things on the internet, and for all practical purposes, they are young adults. So that construct of, requiring a guardian's consent to be able to access a site that collects your data at the age of 17, for example, is just unbelievable for any young person today. But that's being forced on them through this bill, and I think that's a great disservice that the parliamentarians have done to our younger generation.
Well, that's really food for thought, because the presence of children on the internet, the amount of data they generate and consume, is already beginning to become a hot topic of debate. Thank you for that, Nikhil.